first bill we're going to take up today is Senate Bill 394, Prohibit Foreign Ownership of North Carolina Lands. There's a PCS, and without objection, the PCS is before us. And I'll recognize all of the bill sponsors. We have a couple of House sponsors who have a similar bill that's being worded exactly the same that may also wish to speak to this. Who wants to go first? Senator Brinson, come on up. You are the next contestant. All right.
Thank you, Madam Chair, and members of the committee, and thank you very much for moving us up on the agenda. As was stated, this is Senate Bill 394, which passed the Senate unanimously. House Bill 133, which Representative Balkum was the author of, passed your chamber unanimously and is over in the House. She and I have been working over the past year to put those two bills together and essentially make it one effort. And so as was presented this morning in Senate Judiciary, there was a PCS to make these companion bills, if you will, after the fact. And so same. So
go ahead.
Yeah, okay.
Explain the bill.
So I'll explain the bill. Thank you, Madam Chair. What essentially we're doing is banning foreign governments designated as adversarial from buying agricultural land and land within 50 miles of our military bases. That is defined as in the United States Department of International Trafficking Arms Regulations 22 CFR 126. We have included now all of the National Guard facilities in addition to our military bases, drawing 50-mile arcs around them. There is a divestiture requirement. Any new acquisitions that are discovered, then the Attorney General can enforce them through receivership within 3 years. There is a registration requirement for current companies or entities that have land within our state, and they have to register with the Secretary of State or the Attorney General. And then any future purchase requirements for land that meets this criteria, there's an affidavit requirement attesting that the buyer is not part of the prohibited party, and the affidavit will be attached to the deed upon filing.
Thank you. Senator Moffitt, do you wish to offer any further explanation? Senator Balkum, any comments?
I love it.
I mean, Representative Balkum?
That's awesome.
I will get you back into the proper venue with us. Come on up to here.
Until you, do you want to file the amendment, or do you want to ask questions first? Why don't you do that first? I mean, I'm asking, Madam Chair, I'm asking. I'm so sorry.
Okay. All right. I think I'll take back over to the committee. Representative Carver has an amendment. Would you like to explain the amendment, or would you like staff to?
I'm just offering up an amendment that was at the request of Representative Balkum. I believe it's just a technical correction. So,
do you consider it technical? Staff. Okay. It basically takes out a specific section references the chapter 126 instead of the section 126.1. I think that's the explanation. Questions about the amendment? Seeing none, all those in favor of the amendment shall say aye. Aye. Those opposed, no. The ayes have it, and the amendment will be so adopted. Now that we're there, we're back on the bill. Would any of the members like to ask questions or have comments? Sorry?
I'm good.
Okay. Thank you. Representative Liu.
I want to thank the bill sponsors for your willingness to make changes. The original bill in the Senate Bill 394, raised a lot of concerns in the Asian community. I mean, you're talking about the concerns from Republicans and the Democrats, and the business community, the realtors. People were panicking, because there are about 500,000 Asian Americans in our state. And immigration is a long process. So when you first got here, you are, a foreign citizen, and on F1 visa, H1 visa, a J1 visa, J4 visa, and it's a long process for people to get jobs, get green cards, and eventually become U.S. citizens. So during this process, if it's a prohibition on the individuals, these people wouldn't be able to, buy their dream homes and build international wealth for their families. So I really appreciate the partnership from Representative Balcom and the senators and making some changes, and it's much better. But I do have concerns, and I need some clarifications on this bill. When you talk about, I think that the intent of the bill is to prohibit ownership, but there is still a leasing prohibition, right? Like, so the companies who currently operate in North Carolina, they wouldn't be able to lease anything. I mean, I do know that some other states, most states only prohibit ownership because the intent is prohibit ownership. And yes.
All right, we've got somebody who will respond. Senator Benson.
Thank you for the question. And yes, it does prohibit leasing as well, while the provisions to register and the deeds are obviously for ownership.
Okay, did I answer your question?
Follow-up question.
You follow up? If you're referencing a specific section, let us know which section
Yeah.
you're referencing.
And regarding the 50-mile radius, and I asked my summer intern to pull the states, a list of the states that have that have done this similar legislation in other states. Most states have like 5 miles, 10 miles. I think we are the only state that have 50 miles. I mean, I understand 100 miles because that's a prohibition on foreign governments. I mean, it can be 1,000 miles, as far as we're concerned. But in terms of if we currently prohibit foreign companies, I would love for you to define foreign companies. Are these companies only apply to foreign companies under the direct control of foreign governments, or these are the foreign companies that will be owned by folks with green cards who live here in North Carolina?
Has nothing to do with green. Oh, sorry.
Representative Balcom is prepared to answer your question.
Absolutely. So the good part of this is it really doesn't matter how wide the state is. It can do the whole entire state because we have narrowed the definition down. Here's the consequences. It's 22 CFR, the 126, which is the definition by itself. The government, U.S. government, federal government, has already defined it. So therefore, what it says, this is the people that could not do business here, and I don't want them doing business here, is threats to national U.S. security, support of terrorism, military aggression, espionage, sanctions of violations, human rights abuse, weapons trafficking, and activities contrary to the U.S. foreign policy. That is the only companies that this references. So then the company list is on there. So that is it, except for the exception. So let's go to the exception of the good businesses that it doesn't attack under Committee of Foreign Investments in the United States, which is the CFI-US. So therefore, if you're a good actor, it's not even looking at you. It is the people that we've narrowly tailored to these two in the bill. So they're protected. If they're not doing any of that, they're protected. Or if they're working with a government that's doing those, they're not protected.
Yeah, follow up.
Representative Liu.
I just want some clarification. So companies like Lenovo, Smithfield Foods, some furniture companies, tire companies, right, solar companies. I mean, these people wouldn't be applied because they are not tied to any terrorism, right? I mean, the normal companies they would be exempt.
Representative Balcom.
Thank you. So for instance, we'll take Smithfield. Smithfield is actually covered in this bill under CFI-US. They have actually gone through the vetting process that the federal government has put, and they are safe. They're under that exception list because they are doing business. They've gone through the actual process of being a legit business that is good for our state and for the United States. So they are covered. They're probably Novo, I don't know if they are, but if they're covered under the Committee of Foreign Investments in the United States, they've already been vetted and they are covered in this bill. So they're already legit, they're good businesses and they're covered in this bill. So they can do business here.
Representative Budd.
So first of all, I believe that the area covered by this proposed legislation is in fact the purview of the federal government as it deals with national security. That said, I don't believe that the state of North Carolina should condone or endorse activities that could be in violation of federal law or risk national security. But please don't confuse that statement with, I think that this is relevant. I think what this does is it is a solution looking for a problem. Are you familiar with the state of Florida and the ongoing litigation in the 11th Circuit with respect to this exact issue?
I'm not familiar with the state of Florida's legislation. I'm familiar. Oh, I'm sorry.
Go ahead, Representative Balcom.
It's a, follow on.
Sorry,
She's
did
so
you-
excited. She's
No,
so
it's
excited.
okay.
Yeah.
We are very much similar in terms of we
Yes.
get excited because we are.
No,
Wait,
so
yes.
that's why we
Perfect.
tailored the definition so narrow that it's only prohibiting these bad actors and not the good actors.
So, follow on?
Follow up?
Okay. So, are you familiar with the CTA, the Corporate Transparency Act, and that went into effect January 1st of 2024?
I am somewhat familiar, not all the way, but I'm
Fair.
somewhat familiar.
Okay,
Super
don't worry,
good
I'm not going to get in the
Oh,
weeds on that one.
sorry.
So, if you don't mind, if I could follow on with respect
Follow
to
up.
that. So, that particular piece of legislation was designed kind of similar to what you're thinking, right? National security, protection of U.S. interests, and the like, targeting drug trafficking, money laundering, human trafficking, and the like. But I wanted to ask, did you consider the difficulty and complexity of rolling that out across the United States and even in North Carolina in terms of getting those businesses registered for purposes of compliance with the Corporate Transparency Act, which was rolled out, rolled back out, and I think they rolled it back up again?
She asked me a question.
Does
Yes,
anybody
are-
want to respond?
I can respond because I own a small business and have to do it.
Representative Balcom.
So currently I have to do it because I own 2 small businesses, so it's a pain in the butt. But yes, I
Yeah.
take it into consideration.
Okay, so I did it as an attorney for multiple
Follow up?
companies. Yes, follow up, permission ongoing. So the other thing is I look at the corporate transactional side of this, given in light of the CTA. Across the U.S., different states have different rules when it comes to incorporating a business. For example, in South Carolina, you can do it as the organizer and be completely anonymous, which means that a South Carolina limited liability company that registers to do business in North Carolina with our Secretary of State, which is required by law, and they do that, we don't know who owns that company. We don't know if it's one person or 50 or the Iranian government. How does this piece of legislation address those types of situations?
Representative Balcom.
I'll let you.
No, Representative Balcom, I'm not
It
answering questions.
requires them to file the affidavit in the bill. We're requiring them to file it.
Who?
The buyer of who's buying the property.
But the
Follow up?
follow-up, apologies.
Let's see.
So the reason I pose that is the buyer signs the affidavit, correct? But if the buyer is ABC Company, and we don't know who owns ABC Company because it's incorporated in South Carolina, for example, we don't actually know who is behind that corporate shield. That is what I'm getting to with the relevancy piece, and I may be over my
Yeah.
time, but the other thing is, when you go back through this, look at North Carolina's laws. I can sign the LLC paperwork to organize an LLC as the organizer, and you will never know who owns that company. You only know me as the attorney, as the organizer. This piece of legislation does absolutely nothing with respect to addressing the very concerns you put before it and before the committee on national security and not condoning violations of federal law or risking U.S. citizens and our right to safe food supplies and military installations.
Thank you. And this has still got a journey to go. It doesn't go straight from here to rules or the floor. It goes to Homeland Security and Military and Veterans Affairs. So it's still got a ways to go, and you're happy to express your concerns, but I know they've been working on these concerns for a while. Representative Butler.
Yeah, I had a question. Does Representative Balcom, do you know how does and I don't know how CFIUS works mechanically?
So I have a bunch of notes here. Give me just a second. I'll probably have it in here. So I'm going to read some of what I pulled from the CFUS. So basically, it's a federal committee chartered with the U.S. Department of Treasury, and it includes agencies such as the Department of Defense, Homeland Security, Justice Department, Commerce Department, State Department, and its purpose is to review foreign investments and acquisitions involving U.S. business or property, determine whether they pose a national security risk. So there's a committee that puts this process. I was trying to see. It's very extensive. When a foreign company or investor seeks to acquire certain U.S. businesses, infrastructure, technology, or sensitive land, and it's already federally, this is the federal, near a military installation, the transaction may be submitted, and in some cases, to the CFIUS for review. And then it looks through, and I can go through these if that's okay with you.
That's okay. And I think the key thing there is under the federal, it's voluntarily submitted. We're saying it's mandatory.
Yeah.
Yes.
So a follow-up, if I may. And again, this is, I think this is probably way above all of our pay grade, quite frankly. I'm not sure why we're dealing with it. But it seems to me that that process that you've described is, if we tie this bill to that, it seems like we may be creating a dragnet that's going to capture a lot of folks who can't afford that process. I know that that is very expensive, and I seem to recall that this process was used largely for big kind of mergers and big corporations and super sophisticated applicants, and I feel like, and it's very expensive. I know the fees can be in the hundreds of thousands of dollars, just the fees, not the preparation for the application. So my concern is that small, well-intentioned, or medium-sized, or even large businesses who are functioning within our borders are going to get caught in this dragnet. And listen, we want to be an inviting place to do business, and I feel like this is going to chill that desire.
Thank you for the comments. I'm ready to entertain a motion. So we got some more bills. Representative Smith.
Thank you, Madam Chair. I move for
Favorable
report to the PCS of Senate Bill 394 as amended, rolled into a new PCS, unfavorable to the original, with a referral to Homeland Security, Military, and Veterans Affairs.
You've heard the motion. Any further questions or discussion? Seeing none, those in favor will say aye. Those opposed say no. The ayes appear to have it. The ayes do have it, and it will be so reported. Thank you.
Thank you, Madam.
Next, we have a bill for discussion only, and because we're going to take it up because we have a non-member of the committee presenting. So House Bill 1134, secret peeping on minors and increasing punishment. Representative Shepherd, you're recognized to speak on your bill.
Thank you, Madam Chair. Good afternoon, committee. Basically, what this bill does makes the punishment more severe for people that are spying or peeping toms on children. We had an issue in our county, in our state, here in Onslow County. A teacher was set up a video in a classroom where young ladies changed clothes. This a couple of years ago, and they caught him doing that, and he basically had videoed all these young ladies in school as they were changing clothes. He went to trial, went to court, and they found him guilty, but he did not serve any jail time at all. And the community was very concerned that these were minors, and these young ladies were subjected to that, and he sort of walked away with just probation. And so this bill is an opportunity to make the punishment more just for what he had done. And in order to do that, according to our district attorney, we had to address that with this bill and make it a little tougher, the punishment. And I'm free for questions.
All right. Discussion, debate. Representative Butler.
You'll be surprised to know I think it's a fine bill, Phil. I appreciate you.
All right. Further discussion or debate from the committee? We have one member of the audience signed up to speak, and I believe that is, hold on. What is this? Which? Prosser? Mitch. I couldn't get the M. It looks like a W. Mitch Prosser, you're recognized to for a period not to exceed 2 minutes to speak on House Bill 1134.
Absolutely. Thank you, Chairwoman Stevens and members of the J2 committee. I am Mitch Prosser. I have the pleasure of serving as the Vice President at NC Family Policy Council, and NC Family strongly supports H 1134 and the enhanced penalties that this would create for those who commit crimes that will rob the most vulnerable among us of their innocence. We are grateful for the time and attention that has been placed on the work and the details of this bill, and that the sponsors have committed to ensuring that those who are viewing these images, those that are disseminating these images, that they are brought to a sharper point of justice, and that those images should never be seen by anyone. Of course, by enhancing these penalties, this bill not only helps preserve privacy for our most vulnerable, but it helps secure a future that these young people need, that our innocent people need. It's so often taken from them when bad actors take these images into their possession, view these images. So at the appropriate time, Madam Chairwoman, NC Family applauds these efforts, and we move for a favorable report from this committee. Thank you.
Thank you. And because it was filed in the short session, we either got to put money in it, which is going to make it die, or a fee in it, which is going to make it die. So we're working on a criminal bill that's already there. Representative Budd.
Then I have a friendly amendment to this bill.
All right. You want to wait and bring it up next time, or you want to talk to him?
I will bring it up for you to think. Currently, there is no money that has been allocated by certain counties, including Mecklenburg County, for organizations like Safe Alliance and Pat's Place that deal directly and specifically with victims of sexual abuse. And so, for purposes of finding money, it may be worth, for state budget purposes in this bill, have a look at those. They could truly use the funds that they use to help those who are victimized that this bill seeks to protect.
Thank you. Thank you. Seeing no further discussion, we will move on. Thank you. We'll come back.
Thank you, committee.
All right. And I'm going to turn the chair over to Representative Carson Smith to handle, because I'm the only one that does APO.
Thank you, Madam Chair. House Bill 1033, the PCS is, Representative Stevens moves the PCS be properly before us without objection. So ordered. House Bill 1033, Representative Stevens.
Thank you. Thank you, members of the committee. And I will tell you that this is something I've sort of been working on the last 10 years. The North Carolina Dental Board, North Carolina Dental Board examiners were sued, and the case went all the way to the U.S. Supreme Court over administrative procedures and agency requirements. We have worked on language and fixed language that will take care of this. One is antitrust provisions, and the other is having some kind of state oversight. Now, the dental board, as it's currently occupied, elects its own members. There's no outside, no state oversight, no participation in electing members to serve on the dental board. In addition, there were no non-market persons on the dental board. So we have attempted to correct that. What we do is we still have dentists, but they will be appointed by the governor, by the House, and by the Senate. In addition, there's a public consumer that will be appointed by the governor, a dental hygienist who will be able to serve on there, and 2 public consumer members appointed by the Board of Labor. That gives us some more state oversight of this board. The second thing, which the second part of the bill applies to all agencies, and this is language that they worked on the first time the dental board case came down. And what it requires is that you can't just send a cease and desist letter and demand that people stop practice, okay? That takes court supervision and interference. The whole thing that happened in this case is that the dental board decided that teeth whitening was the practice of dentistry, and therefore no one else could do it. There were all these little, if you remember, there was kiosks set up in the mall, different people applying whitening stuff. That's what went to the U.S. Supreme Court. The Supreme Court also said if you consider it the practice of dentistry, you need to have modified your statute with the General Assembly, or you needed to go to rules review and have rules review determine that it's there. Neither one of those things have happened. And recently, the dental board again demanded someone to stop teeth whitening, and this time not just teeth whitening, but attaching jewels to your teeth. That wound up in a lawsuit that was ultimately settled. But this will help them not run into that problem again by saying that you've got to go through the board rulemaking as you're supposed to. unlicensed activity is described under sections A and B, and then a specific provision of how you notify. You're notified that we're expressing the opinion that you're engaged in dental practice and you're not a dentist, or you're engaged in electricity and you're not an electrician. And so they don't have a right to demand you stop. They have a right to seek a declaratory judgment saying that you are violating the practice. Gets injunctive relief. All of this was all of the other agencies said after the dental board case. This is sort of what we've been doing so we don't get in trouble again. And we're just saying, dental board, you've got to comply with it too. So it applies to all of the members. And like I said, it just changes the makeup of the dental board to get them more into compliance. When we had a meeting in Administrative Procedures Oversight, we heard from the dental board examiner's executive director who says he's not adverse to this legislation that would be helpful in strengthening the state immunity claims that the board could face. And so that's what we've been doing. It has nothing to do with dental, what are they calling them now? Dental service organizations or dental management organizations. This has absolutely nothing to do with that. This is simply about the practice of dentistry and ensuring that the dentists are not engaging in what is perceived and has been ruled to be antitrust activity and lack of state supervision.
Thank you, Chairman Stevens. Questions from the committee? Representative Butler.
So let me make sure I understood you, Chair Stevens. So because the supposition, I think, what I've heard is that people are afraid that this is a move to have non-physician owned dental practices. So if I understood what you said, this is not about that.
Right.
Would you be amenable in the next round to making some clarifying language in there to make that a prohibition, to suggest that as a matter of public safety, if you are holding yourself out as a dental practice, that you are owned by a licensed dentist?
Representative Stevens.
Thank you. I'm happy to look at any language that you bring to me, but I'm not sure if that's an appropriate part of this bill. There's just no mention in here. It says the practice of dentistry is the practice of dentistry is the practice of dentistry. Now, I know we had, when I first got here, there were some groups, and it would take specific legislation to do this, that were looking to have non-lawyers own law practices. There's nothing in here, and it would take very specific legislation to create that. So I don't know that it's appropriate for here, and I don't want to muddy the water any further than I have. I simply want to get the dental board to get in compliance with what other boards are doing, what is in essence state supervision, and what is in essence how you go about making a complaint.
Okay, so just a quick follow-up. So is your position here today that only licensed dentists shall practice in this state? No, there will be no ownership of any middle management or any other entity of a dental practice.
I'm saying none of that's included in here. I have not researched the law enough to know. I just don't know of any law that has allowed that, and I'm happy to defer
Well, but I mean,
to staff.
I'm asking your opinion about it.
I don't, like I said, I don't want to give my opinion. I would defer to staff as to whether there's any, because I've not researched it. I don't think there's any provision that allows that currently doesn't.
Somebody for
We've got
staff
some
know?
people. We've got some people who are going to speak for the public who say they know. So staff? Anybody want to venture an opinion?
Mr. Moran Bates.
Jason Moran Bates, Legislative Analysis. I can only echo what Representative Stevens said. Nothing of that nature is in this bill. I don't believe there are any laws regarding that right now. I know that I believe there are some administrative rules with criteria that you have to meet in order to run a dental practice. As for these kind of third-party administrators, there are some administrative rules that also detail the extent with which they can be involved in running the dental practice as well.
Madam Chair, would it be appropriate then to ask a follow-up of staff to just hammer that down for us between now and the next committee meeting?
Okay, I think we're gonna pass this bill out.
No, I mean, before we get to the next committee, so that we'll know for the
You
future.
can ask the staff to do anything you want.
And we can, yeah.
Well,
Follow
I
up.
don't know, they kind of work for
Can I
her
get
right
some
now.
more answers?
Yeah, okay, thank you.
Representative Bud.
So I want to say the concern, as I I read through this, being a licensed professional like yourself as a lawyer, this case is 2015, and I went back and I reread the Supreme Court decision last night, as well as several law review articles and analysis of how boards across the nation, including those in North Carolina, have made changes for all intents and purposes to how they provide oversight or require training and education so as to prevent this from happening. Because essentially, as I read this decision, the holding by the Supreme Court was that because teeth whitening was not defined as the practice of dentistry in 2015 or 2013 when it started, that the dental board, by sending those cease and desist letters that they did to the non-licensed folks doing the teeth whitening and Teddy's van out back or the mall kiosk, essentially it was an unfair restraint on competition and the market and trade. So the concern that I've got is the language in here about education on antitrust law and state action immunity. You mentioned, you said there was a recent issue in Raleigh with dentists. That's my question, is getting to that.
Representative Stevens.
Okay, there are currently 2 cases out there. There's
Okay.
one in Raleigh with the unauthorized practice of dentistry.
That's
woman
the
was
Ebony
sued-
and
yes,
Bryan
yes.
case. Or,
Okay,
yeah.
there was another case, and I've got some other people who can tell you. I actually have a copy of the opinion. It was a lawsuit in the last year and a half
Okay.
that actually was the same issue. Teeth whitening, fixing a jewel to it, things that the Board of Dental Examiners had never gone back and renewed and said, this is the practice of dentistry, Administrative Procedure Oversight, or
I follow you.
rules, yeah.
Yeah.
Rules had never been changed. Law
Okay.
had never been changed. It was the exact same problem. Now, it's a little bit more than just state oversight. It was antitrust, and it was not having consumers involved. It was having the dental board, dentist controlling the dental board completely. So some of the state oversight comes from having them appointed by other agencies and then being followed.
With all due respect, yes, thank you. With all due respect, I don't believe that that is what the Supreme Court opinion in the North Carolina Dental Board versus the FTC said. They were specifically concerned about an unreasonable restraint on trade by the dentist against non-dentists for practices and procedures that were not considered the practice of dentistry in North Carolina. So when we get into this and we look at it, coming back to this particular piece of legislation, Representative Stevens, what I'm looking for is not 1 or 2 cases against individuals who are practicing teeth whitening and placing jewels on teeth, but where has the dental board in the last 11 years failed to amend its rules and regulations that govern it to ensure they don't restrict trade? And how many times has the dental board been brought before the FTC or another court because the dental board on behalf of licensed dentists is unreasonably and unfairly restricting trade?
Representative Stevens.
Thank you. A lot of people won't pursue those cases because they're very expensive, but there was one a year and a half ago with the exact same situation, and that was the motion to dismiss, was the brief basically from the U.S. Supreme Court case.
Follow up.
No, I'm not talking about, I'm talking about the dental board. They are on behalf of licensed dentists sending something like a cease and desist letter or allowing their dentist to shut down and curtail trade of non-dentists for activities that aren't covered. That's what I'm looking for. It's a restraint of trade issue because that is the Sherman Act.
Sure. Part of it is having some non-practitioners on the board to give that opinion. Second is using the court system to review as opposed to not review. Okay? They're not required to do that, and I don't know whether they've continued to send these cease and desist letters. That part applies to all boards and agencies. When we had this meeting in 2015-16 after this opinion, this is what they all came up with as what would help them meet those qualifications. It wasn't me. It wasn't one attorney. It was a bunch of people who represent agencies and boards came together and said, based on the case, these are the things we think we will work. Now, I'll share a secret with you. Probably something I shouldn't say because we're in the legislature. The only reason it didn't get passed in 2015-16, whenever I was doing it before, is there was a senator who held it up because what he wanted was a statewide board of boards, and that every board must report to that statewide board of boards to see if they've gotten things done. And I said, not another layer of administration, period.
Final question.
Follow.
So, I'm not going to belabor you with all the boards that are out there for all the licensed professionals in North Carolina. But when I look at this, are you then going to propose that boards that don't have any consumers or appointments by the Senate, the House, or the governor all be changed in order to do so? And that includes, that's everybody from the state bar to the CPAs to the medical board to physician's assistants, nurse practitioners, and the nursing board and the like, because we are not all created equal. We are not all directly subject to some state oversight, although we are considered to be state, under the governance of the state. And so what I'm seeing is a slippery slope where suddenly licensed professionals' expertise is going to be diluted because of some concern that somewhere along the way we're going to unfairly restrict trade based on somebody who is doing teeth whitening illegally.
Thank you, and I appreciate that. And I did ask staff about that. And almost every board we've sort of looked at has consumers on it, except the dental board. Almost every board we've got has some appointees outside of the boards that they're governing, okay, as opposed to just the board doing it. We do have some speakers, I think probably pro and con, and we're still happy to answer questions.
One quick thing, Mr. Moran Batts, I think Representative Butler, I think he may have an answer to your question.
Jason Moran Bates, Legislative Analysis. The first thing I would like to do is correct a misstatement I made. Actually, under General Statute 90-29A, only licensed dentists can own, manage, or supervise or control a dental practice. So I was incorrect when I said that's not in statute. That is in statute. Third parties can provide business and management services to dental practices. These are the third party things we were talking about. Under the administrative code, those things have to be approved by the board, and no arrangement will be approved if it permits control over clinical aspects of the practice, control of patient records, control over or input into clinical practices, control over personnel, authority to approve contracts, control over transfer of ownership. Payment to the third parties varies based on the profitability of the dental practice, or payments to the third party that exceed the profits of the dental practice. So that's the kind of state of law for controlling dental practices and running the administration parts.
We've had 3 sign-ups. If you would come up when I call your name, give us your name and who you're with. Jim Goodman, you have 2 minutes.
Thank you, Representative Stevens, and the full Judiciary 2 committee. My name is Jim Goodman. I'm the CEO and Executive Director of the North Carolina Dental Society. And on behalf of dentists across North Carolina, I offer our perspective. The North Carolina Dental Society strongly opposes this legislation. Simply put, this is a solution in search of a problem. Our position is based on data and evidence, which we can provide in more detail after this committee meeting, if so desired. North Carolina is an excellent place to practice dentistry because our current laws protect both patients and clinical autonomy of licensed dental professionals. Just like the North Carolina State Bar, the dental board should continue to be elected by licensed professionals within that profession. Dentists are the subject matter experts best equipped to evaluate standards of care, patient safety, and professional competence. Removing peer elections of those most committed and qualified risks making the dental board vulnerable to political influence rather than decisions grounded in clinical expertise and patient protection. The North Carolina State Board of Dental Examiners is effectively fulfilling its most important mission, protecting the public. How do we know? Because in North Carolina, malpractice paid claims are approximately 1/3 of the national average. Paid malpractice claims are the indicator of adverse patient outcomes. And in North Carolina, we are significantly outperforming national averages. In terms of the climate, can I finish?
Got it? Is that the stop?
Yes, ma'am.
Okay.
Can I?
Finish your sentence.
I have just two sentences. North Carolina's dentist workforce has grown faster than any other state over the past decade, increasing by 20.5% per 1,000 population. This is more than double the next closest state. Dentists are migrating and staying to practice in North Carolina like in no other state.
Thank you, sir.
Thank you all.
Bill Croft? I'm just saying, I'm giving you the name.
Bill Croft.
Yeah, you just told me to pick you up.
Okay.
It's pretty sensitive.
Thank you, Mr. Chair. Representative Stevens, I was going to come by your office to ask you this question because that's really all I have. I'm with the North Carolina Respiratory Care Board. I'm the executive director, and I want to thank you for the helping us with the 2015 issue because that would have been a disaster. But what I have a question about is on page 4, 93B-17, paragraph B. It requires all occupational license boards to any interpretation, clarification, and delineation of the scope of practice of an occupational board shall be adopted as a rule. Okay, logistically, we're in the throes of doing rules readoption 10-year process. I'm imagining having to, if somebody comes to us and say, we need an interpretation, and we say, no, it's not within the practice of respiratory care, do we have to adopt that as a rule? According to this, it sounds like we would. I just want to get some clarification on that.
Representative Stevens.
And I may defer to Jason Moran Bates, but you have to, you've adopted a scope of practice for your facility, your area. If someone starts doing something and you think it's wrong, then you seek the courts. You can't just stop them. You're supposed to seek the court's interference unless it's clearly there. We'll go back to the dental board case. The dental board has never declared or had in its administrative procedures that teeth whitening is a dental practice because it would have to convince the board that that's authorized under statute or that it was that dangerous. And so that's what this all goes to is if you think you're expanding the scope of your practice, you must get the permission, you must go through rules review or have statutory change. I think, and I'm happy to defer to staff.
Thank you. Tom Fitzer.
Madam Chairman, members of the committee, thank you for your time. This bill simply brings the dental board into line with how every other state in the country does it and almost every other health occupation board in North Carolina is done, not through the election of market participants to govern their fellow dentists, but appointments by the legislature and the governor and the labor commissioner and the state auditor. Mr. Goodman's argument is not with this bill, it's with the Federal Trade Commission and the United States Supreme Court, both of which opined over 10 years ago that in order for the dental board to have active state immunity, like every other occupational board in the state, it must move away from only having active participants controlling the dental board. And so this legislation simply does that. Mr. Goodman says that the dental board is only about patient safety. But when Governor Cooper appointed Sheetal Patel to the one position that's not elected, the governor's appointment to the Consumer Advocacy Board, and Mrs. Patel was the wife of a cardiologist in Wilmington who died in his dental office during a routine procedure and has since become a nationally recognized advocate for patient safety, members of the dental board were quoted as saying, we're not going to have the dead cardiologist's wife who wants to change the face of dentistry on the dental board, and they scuttled her appointment. So if health and public safety was really at the cornerstone of their mantra, then they would not have opposed that. This is a simple, straightforward bill. It has nothing to do with who owns a dental practice. That is in statute. No one challenges that or questions that. only licensed dentists should own dental practices. My father was a dentist. I agree with that. I love the profession of dentistry, but the dental board, according to the Federal Trade Commission and the United States Supreme Court, needs to change the way it's configured. Thank you very much.
If you don't mind, if you could please identify yourself.
Tom Fetzer.
Thank you. All right, one more quick question, Representative Bud.
Now you know I have two because I wanted to know where Mr. Fetzer was from and who he was speaking on behalf of.
Yes.
And then I have my question.
I'm a low-life lobbyist from Raleigh, North Carolina, and I represent Heartland Dental.
Well, I'm an elected official.
Representative Bud.
Thank you.
One quick question, please.
The question has to do with in what capacity or to what degree was the set of guidelines from the FTC, its staff guidance guidelines that were issued following this decision were consulted, because a number of the statements that I just heard directly contradict that. That is FTC guidance. Following specifically this court decision, this bill is based upon.
We got your question.
I understand, and I may have to defer to staff if you want to, but I wanted to correct one thing he said right away, and that is we, as the General Assembly, appoint various attorneys to serve on the state bar. We, as the General Assembly, appoint people to serve on the medical board. We appoint attorneys, we appoint consumer advocates. We all have our assigned positions. This is, as far as I know, the only board under Chapter 90, professional boards, that elects its own, keeps its own internal. That's the problem. There was not a lot of state oversight. And then the automatic telling people you have to stop what you're doing, you know, we can say, the language is in there, we believe this is the practice of dentistry. If you don't stop, we're going to go to the court. That's appropriate. That's why we put the language in there. But yes, every board started doing this after 2015.
Thank you. Representative Pirtle's hand was up. It's 10 till. This is the last question. We'll go to a vote. Representative Pirtle.
Thank you, Mr. Chair. A very simple question. Madam Chair, when we was drafting this piece of legislation, did you consider the template that the North Carolina Medical Board has for their board, or did you look at their board to see the makeup of their board when this was being formulated?
Representative Stevens.
And I would defer to staff. We did this in Administrative Procedures Oversight. We actually have bill like this already over here from the Senate. So staff, did you consider any particular template?
Jason Moran Bates, Legislative Analysis. I was not involved in the drafting of this bill, and legislative confidentiality would prohibit me from discussing what might have gone into it, even if I had been involved.
Thank you.
We have looked at various boards.
Representative Sarah Stevens moves for a favorable report to the PCS of House Bill 1033, unfavorable to the original, with a referral to health. All those in favor say aye. All opposed, no. Any of the chairs, the ayes have it. The ayes do have it, and the bill passes. Turn it back over to the chair.
Seeing no further business, we are concluded.